do you agree that in those circumstances the survivor should have to make the allegation in the presence of the accused?
Sorry, I don't understand your question. Could you rephrase it?
Do you agree that there are no circumstances in which the survivor of a sexual assault should have to make her allegation in the presence of the person whom she accuses of having assaulted her?
I agree that that is the case.
And as I understand you, you're saying on your understanding that that's not required by your rules. In other words, your rules do not require the survivor of a sexual assault to have to make her allegation in the presence of the person whom she accuses as having assaulted her.
If I understand your question correctly, from what I've heard from Mr. Spink's testimony, that is not something that we require now. I'm prefacing this in the fact that it's not my field that I work with every day. Mr. Spinks and those who work in the service department work with these matters, but that is my understanding.
Yes. And so do you accept then that that should be made clear in your documents, manuals and instructions? In other words, that it should be made clear that a survivor of a sexual assault should not have to make her allegation in the presence of the person whom she accuses as having assaulted her?
Absolutely.
Now, Mr. Jackson, can a branch committee publish its own manuals and guidelines in respect of judicial committee procedures for responding to allegations of child sexual abuse?
I would think it would be unusual for that to happen. Seeing it's not my field per se, I couldn't give an inclusive answer with regard to that, but as far as a general principle goes, I would expect that they would get back to the service committee on it.
Well, what we see in the documents that we have that govern this issue currently is that they are documents which originate under the auspices of or with the approval of the governing body. So I'm referring to... Yeah, sorry, Mr. Jackson.
Sorry, my apologies.
So I'm referring to organize to do Jehovah's will, shepherd the flock of God, and the guidelines that are published to the branch committees.
Thank you. It's a rather long question, but if I've understood it correctly, we would expect the general framework of what we do to be published as approved by the governing body. But you see, when we say published, letters are published by the local branches that indicate any variance that may need to take place with regard to those policies. So that's why I was just hesitant to say that it's all-inclusive.
Well, if the Australia branch, for example, was to decide that the investigative step which precedes the appointment of a judicial committee need not be done by two elders, but can in Australia be done by a woman acting on their behalf, would that be something that would be open to the Australia committee to follow or to adopt?
Mr. Stewart, I certainly would hope that the Australia branch committee would get back to the service committee with the reasons why that's needed, and then eventually I would hope that would get to the governing body so that we could approve whatever changes are needed worldwide.
But it may be that the branch committee in Australia has a different view on these matters than the branch committee in some other country. We'll take one close to home, New Zealand, for example. Well, that may, let me do one further afield anywhere, if you like. The Philippines may take a different view. Is there space for the branch committees to have different investigative procedures in different parts of the world?
To answer your question, the answer is yes, that is possible, but if the reason for doing so is to avoid trauma, then that's something the governing body is interested in. We want to see how we can encourage all the countries to avoid that. But if it's a matter of technicality that they need to do it a certain way, then yes, we would expect they would at least notify us, and there could be differences.
Mr. Jackson, is there any biblical impediment to a woman being appointed to investigate an allegation?
There is no biblical impediment to a woman being involved with the investigation. In fact, I think... Oh, sorry. I'm sorry, Your Honour.
No, you continue.
And I think that's one of the benefits of the Royal Commission, as what has been brought to light, is that certainly it is good for a woman to be involved, with particularly some of these sensitive areas. But if I could just mention, many of our publications are very broad in aspect. We're not just talking about this one aspect of child abuse, which is a horrific crime, but it can also, the same principles are used for other sins such as drunkenness and other things the Bible mentions. But in this sensitive area, yes, I think the Commission has clearly shown that it would be good for women to be involved.
Is there any biblical impediment to a determination, a judicial determination, being made by a body which includes women, although the elders thereafter may respond in terms of the as the decision maker in relation to what happens to someone after a decision has been made as to the truth or not of an allegation?
That's a good question. Could I just mention first, Your Honour, something, please bear with me on this. The judicial system that Jehovah's Witnesses use is not in competition with the criminal justice system. We respect that, and we feel that that's something that the community needs to make use of. But also, if I can just highlight, any victim is not viewed as someone that needs to stand before a judicial committee. They did not do anything wrong. They're the ones that have been victimized. They need the help. Now, to answer your question directly, women can be involved in this very sensitive area, but biblically speaking, the role of judges in the congregation, it lays with men. That's what the Bible says, and that's what we endeavour to follow.
Can you give me the reference for that?
Yes. In the scriptures,
that is judges being only men. Not elders, but judges being only men.
Okay, I would have to check it. I think Deuteronomy is one of them, but with regard to 1 Timothy chapter 3, 1 Timothy chapter 3, and I'm sure Your Honour, you're very familiar with this. In verse 1, the statement is trustworthy. If a man is reaching out to be an overseer, he is desirous of a fine work. The overseer should therefore be irreprehensible, a husband of one wife, moderate in habits, sound in mind, orderly, hospitable, qualified to teach, not a drunkard, not violent, but reasonable, not quarrelsome, not a lover of money, a man presiding over his own household in a fine manner, having his children in subjection with all seriousness. In biblical times, the same expression that is used for elder is also used for older man. And when we're translating, of course, that is my field, sometimes it is hard to decide whether it means elder as in a position or older man. But definitely when it speaks of judges at the gates in Israel, we're talking about older men. But I apologize, Your Honour, seeing that you asked this question, I cannot give you the exact scriptural reference, but we'll be happy to do that.
We would appreciate it, because one possible modification to meet this issue of the lack of women as judges of allegations brought forward by women against men may be a modification of your process to include women in the judicial determination step. You understand?
I do understand, Your Honour, and we will make sure you get those references.
And can you understand how a woman, a young woman, any woman might feel when allegations which she makes of having been sexually assaulted by a male are determined exclusively by men?
In the context of a police station, I can understand that, Your Honour, but please, may I also mention the role of these elders. They are friends of those in the congregation. Their role is to shepherd, help, care for. And so although perhaps a young person may feel that way, and we would do everything we can within the Bible parameters to make sure that that is eased so that a person isn't put in that very difficult situation. But still, ultimately, the decision, maybe without that person, would be made. And the decision is not concerning the criminality. That is the criminal system. The decision is concerning the spiritual cleanliness of our congregation and the rehabilitation of those that commit sins.
That's to concentrate on the abuser. But what I'm talking about is the position of the person who's been abused. Do you understand?
I do understand that.
See, all that you've just said is talking about it from only one perspective, you see?
So from the other perspective, with a victim, the main thing for us is helping, supporting, and guiding, and women will be involved with that. You see, the Judicial Committee is not judging the victim. The elders in the congregation and the women in the congregation have the obligation to give full support to any victim.
Well, that may be so, but the point I was seeking to have you address was, can you understand how a woman might feel when allegations which she brings forward against a man in the congregation are judged, are considered and judged entirely by men?
Obviously I'm not a woman, so I wouldn't like to speak on their behalf, but the two of us, I'm sure, could understand from what has been expressed and believe that perhaps there would be a hesitancy there.
And can I add this to the question, because it's one of the factual circumstances we face in this hearing. Can you understand the circumstance for a woman who brings an allegation against an elder, who is a friend of the others, who must judge the truth or otherwise of the allegation? Can you understand how that person must feel?
I can try to understand it, Your Honour, yes. But again, could I ask, and again, this is not my field of activity, but as far as I understand, we have a process in place whereby a neutral member, like a circuit overseer, will be involved with such a sensitive case.
It would be the case, would it not, that even a circuit overseer is going to know an elder well?
They should be familiar, but they also know the victim well. You see, it's not taking into consideration the spiritual responsibility. You see, these elders are not paid to do their job. They do it because of love and concern and wanting to shepherd the flock. And so I think what we're missing is the spiritual element to this whole thing, where people are comfortable talking to one another.
Well, I don't know whether you heard the evidence of the survivors here. Did you hear that evidence?
No, unfortunately, that was a bad time for me caring for my father. I apologise, but I will look forward to hearing a summary of it.
Yes, Mr. Stewart.
Yes, because, Mr. Jackson, for example, the elders who hear these allegations, one of the things they have to do is to measure the credibility of the person who says that she suffered abuse. Is that not right?
Yes, as a prosecutor would also measure the evidence that he does before he goes to a case.
Well, not so much the prosecutor, perhaps you're thinking of the judge.
Sorry, no. If I understand correct, well, I'm going way out of my field because I'm not a lawyer, but I thought any case that would go to the police and then brought to the prosecution, you'd have to at least establish there was some validity.
Yes,
maybe that's not the case in Australia.
Well, the point is this, Mr. Jackson, isn't it, that you've appreciated, I think, that an elderly man may be in a difficult position to understand just how a young woman, for example, making an accusation or an allegation of child sexual abuse feels in having to make that allegation.
That is true, but at the same time, perhaps someone who's never experienced the trauma that these victims have felt, even a woman may find that very hard as well, because it's such a personal experience.
But you'll accept, I'm sure, that in many instances where a woman or young woman makes such an allegation, she would feel a lot more comfortable having to make the allegation and explain the circumstances to another woman.
I can't say that I would give a comment on that, Mr. Stewart, because you see, again, it takes away the consideration of the relationships in our congregations. It's not like your churches where people just go to church and don't talk to one another. Their congregations do become familiar, and there can be a friendship. So I agree at the point you're trying to get at. We need to know what the victim is comfortable in doing with regard to who they speak to.
Well, you gave us a scripture, 1 Timothy 3 verse 1, which, as I understood it, was the authority for the principle that, as it's put there, an overseer, but in, I think, modern language, an elder, must be a man. Is that right?
That's correct.
And is there a scriptural reference, and perhaps this is the one you said you'd need to come back to us on, is there a scriptural reference which says that the investigation of allegations of serious misconduct must be done by an elder?
If I could just clarify your question a little, Mr. Stewart. You see, what I think you've heard in the Commission is that we have said that women can be involved in all these various aspects leading up to the actual decision-making, whether or not someone is spiritually qualified to remain in the congregation. So just that one aspect, the actual Judicial Committee itself, is where we believe that men would be involved.
Well, Mr. Jackson, that's the question I was putting to you, you see. I was wondering whether you could have a structure which meant that the judicial decision as to whether or not the allegation was true could be determined by a body capable of having women represented on it, and that body's decision would then be taken to the elders in relation to decisions to disfellowship. Do you understand?
I understand, Your Honour.
Well, is it possible to make that change?
It is possible to make sure that elders are fully aware of the whole story. But for women to be elders in the congregation, that is not possible.
No, Mr. Jackson, I wasn't asking you that. I was asking you to consider. Sorry. I was asking you to consider whether the process may involve a determination which we outside the church would call a judicial determination. That is the allegation true or false? And then that decision having been made, the elders would then make a decision as to the consequence, being disfellowship or otherwise. Do you understand?
I do understand.
Could women be involved in the determination of whether or not the allegation is true?
Well, Your Honour, if I could say, I think they already are involved.
Not in the decision, not in the decision, Mr. Jackson. Please address my question.
Okay. Yes, well, please, could I just use an example? If an underage child it says that something has happened, and then two women are involved with helping that person, surely they have to decide whether or not the facts are true and present those to the elders. Otherwise, how would the elders know what the facts are?
Mr. Jackson, you're not dealing with my question.
I'm sorry, I apologise.
Would you like me to put it again? Would you like me to put it again?
If you would, please.
Your process at the moment has a judicial determination which is made by the elders. And that's the point at which a decision is made as to whether the allegation is true or false. Do you understand that?
Mm-hmm.
You do?
I do understand that, Your Honour.
Is it possible for the process to be modified so that that decision can be made by a body which could include women? That is, the decision as to whether or not the allegation is true or false, made by a body which could include women, and that decision would thereafter be acted upon and a decision made as to whether or not to disfellowship by the elders. Do you understand?
I do understand, and I apologise, Your Honour, for not answering directly. I didn't understand fully what you were saying. The answer, Your Honour, is such a situation would be worthy of us considering and doing research and checking the scriptures. Yes, the possibility of considering that is there.
Thank you.
Thank you, and I apologise again.
Mr. Jackson, I'd like to refer you to Shepherd the Flock of God, which is tab 120 at page 71, ringtail 72. Now, this is the manual for elders, and it's been applicable since, as I understand it, 2010. Is that right?
This is, yes, that appears to be the case.
And would it be the case that this manual came through the processes of the writing committee?
This manual would have been prepared with the help of the service departments, and the service committee would have prepared this information. And yes, the writing committee would have needed to read everything and check to see it scripturally applicable.
Yes. And what I'm showing you page 71, but that's in chapter 5, which is headed determining whether a judicial committee should be formed. And it starts out by setting out various wrongdoings, serious ones, including manslaughter, attempted suicide, veneer, and so on. So that's the context. But you'll see at paragraph 37, it says, even though a Christian has been accused of wrongdoing serious enough to require judicial action, a judicial committee should not be formed unless the wrongdoing has been established, and the word established is in italics. So my question is, who is it who decides whether the wrongdoing has been established?
So it is my understanding that two elders normally would investigate the matter to see if there is some substance to the accusation, having in mind, as you mentioned, this could be ranging from someone getting drunk to someone committing immorality and so on. So those two elders would at least see if there was some basis of the accusation, and they would get back to the body of elders, who then would appoint the judicial committee.
Yes. So then the question is it scripturally necessary that that role is performed by two elders as opposed to, for example, a woman appointed for them?
May I ask, Mr. Stewart, is this the same question that His Honour asked, or is there a difference? Are you just emphasising the point?
Well, I'm trying to understand your answer, Mr. Jackson. So if you can just address yourself to my question. What I've sought to do is to identify a very specific decision in the process. It's the decision as to is the wrongdoing established, and you've said that that's done by two elders who then report back to the body of elders, which then appoints a judicial committee. So I'm asking scripturally, is there room for that decision as to whether the wrongdoing has been established to be anyone other than elders?
Good, I understand your question, Mr. Stewart. Could we take the case of where the two elders cannot speak to the victim, that perhaps they don't want to traumatize the victim, and maybe two women that are very close to the victim are able to speak to them? In a setting such as that, all the elders would have is the testimony of the two women with regard to the testimony of the victim. So in that way, the women are saying whether they feel that it's a valid case or not. So the answer to your question is, yes, women can be involved scripturally.
But you know, Mr. Jackson, my question had nothing to do with involvement. It had to do with who makes the decision. The person who makes the tea is involved, in a sense, if they bring the tea in when the decision's being considered. I'm not talking about involvement, I'm talking about who makes the decision. Am I to understand your evidence is that it must be elders who make the decision?
That is my understanding.
Yes. And are you able to furnish a scriptural reference for that? In other words, where it is that it's provided in the scriptures that is necessarily so?
The principle that we were discussing before is the headship principle found in 1 Corinthians chapter 11, and I'm sure, Mr. Stewart, you've already referred to this in the commission, but please bear with me as we look at it. 1 Corinthians chapter 11 and verse 3. You have it there already?
This time I'll be grateful for the page number, Mr. Jackson.
Okay, so 1536. Thank you. So, verse 3 of chapter 11. But I want you to know that the head of every man is the Christ. In turn, the head of a woman is the man. In turn, the head of the Christ is God. So, in the church decision-making arrangement, is based on the headship principle that we have in the family and in the Jehovah's Witness community as a whole. That scripturally, the men make the final decisions, but that does not mean that there is no input from the women.
Yes, thank you, Mr. Jackson. While you're in 1 Corinthians, perhaps you would take a look at 1 Corinthians 14, verses 33 to 35.
I have it already, yes.
Which says that, for God is a God not of disorder but of peace, as in all the congregations of the holy ones. Let the women keep silent in the congregations, for it is not permitted for them to speak. Rather, let them be in subjection, as the law also says. If they want to learn something, let them ask their husbands at home, for it is disgraceful for a woman to speak in the congregation. Now, as I understand it, that's not applied in the Jehovah's Witness organization. In other words, you do allow women to speak in the congregation.
I'm sorry, you have two questions there. Can I answer the first one first? Jehovah's Witnesses do follow what is stated here. I can explain. The second one is, yes, women are allowed to speak in the congregation. May I explain to you the reason why I feel we do follow what is here?
Yes, of course.
Okay, so you notice in verse 34, that's where it says, keep silent. But if you look up at verse 28, there it says, but if there is no interpreter, he must keep silent. So the expression keep silent is referred to a male, And then verse 30, where it's talking about prophets, and then if one, in verse 30 it says, if another one receives a revelation while sitting there, let the first speaker keep silent. So this chapter is talking about orderly conduct in the church meetings or in the congregation meetings. So in verse 28, if someone starts speaking in another language but there's no interpreter, the scripture says, let him keep silent. Now it appears that in the congregation there was a problem because some women were actually challenging, arguing, debating with the men who were taking the lead in giving teaching. Now, you may not feel that that is the case, but that's the context of what is said here. And in chapter 11, it refers to the fact that a woman could speak with a head covering. So I think a very literal interpretation of verse 34 and 35 is not appropriate in the context.
Are you able to give an overarching explanation as to when it is that what is said in the Bible should be taken literally and when it should be given an expansive interpretation as in this instance?
Very good. The answer is Jehovah's Witnesses, you see, it's not a matter of 7 men in the governing body taking one verse and saying, what do you think it means? What do you think it means? Jehovah's Witnesses try to use the Bible to explain itself. So here in 1 Corinthians chapter 4, if we were to take the viewpoint that this literally means that a woman cannot speak, then we would be not going in accordance with the context. So the answer to your question is you have to have the whole picture, and that's something that for yourself, and this is obviously said in all due respect, someone who reads the Bible their whole life should understand the whole picture. And if I, perhaps by means of helping you with regard to that, there are 2 other scriptures. One is in 1 Timothy chapter 2, which I believe is referred to in the commission. 1 Timothy chapter 2, that's page 1588. And there it says, verse 11 and 12, let a woman learn in silence with full submissiveness. I do not permit a woman to teach or to exercise authority over a man, but she is to remain silent. Now you notice the asterisk gives the alternative to that, to remain calm, remain quiet. So obviously this is talking about the role of women not jumping up excitedly, arguing with others. And it's similar to what 1 Peter, and please bear with me, 1 Peter chapter 3 says with regard to a woman who is married to a non-Christian. And in 1 Peter chapter 3, that's page 1623. Mr. Stewart, have you got it?
No, I haven't, but I'm sure you'll read it to me, Mr. Jackson.
Okay. And verse 1 of 1 Peter chapter 3, in the same way you wives be in subjection to your husbands, so that if any are not obedient to the word, they may be won without a word through the conduct of their wives. Now, to take the position that the expression without a word means they would never, ever, ever speak to their husband would be a misapplication of Scripture. So the governing body, when we consider these things, is very much aware of trying to get the whole context of things. Otherwise, it's like asking 2 people for an opinion on something and getting 3 different opinions. If someone just takes one verse, they can have all sorts of opinions about it. But the work of Jehovah's Witnesses is to try and understand the whole Bible as one message from God. Now, I don't expect that you would have the same viewpoint, but I thank you for at least letting me express our viewpoint.
Mr. Jackson, let's make it a little more concrete then, in a very specific example. Now, you'll know that one of the things that's emerged in the last couple of weeks, that in Australia at least, amongst the Jehovah's, or in the Jehovah's Witness organization, there's a practice of not reporting child sexual abuse allegations to the authorities unless required by law to do so. Do you accept that?
I'm not familiar with the statistics or the general practice, but I can tell you why there is a spiritual dilemma because of this question.
Well, that's what I'm driving at. So perhaps you can address that question specifically, which is this: is there a scriptural basis to that policy being, or practice being, not to report child sexual abuse allegations to the authorities unless required by law to do so?
Thank you for the opportunity to explain this. I think very clearly Mr. Toole pointed out that if the Australian government and all the states was to make mandatory reporting, it would make it so much easier for us. But the ethical, or the, let's say the spiritual dilemma that an elder has is to consider, how did he get the information that he has been told? Now, there's a scriptural principle in the book of Proverbs, chapter 25, and I'm not saying, Mr. Stewart, that any one of these principles takes precedent, but it is something that the elder would need to take into consideration. So Proverbs 25, verses 8 through 10. That's on page 905. That's Proverbs 25, 8 through 10. Do not rush into a legal dispute, for what you will do later. For what will you do later if your neighbor humiliates you? Plead your case with your neighbor, but do not reveal what you were told confidentially, so that the one listening will not put you to shame and you spread a bad report that cannot be recalled. Now, I'm not saying, Mr. Stewart, this is the only factor, but it is one factor that all ministers of religion have grappled with when it comes to an issue such as this. The second issue is that elders are told, as is mentioned in 1 Peter, and the 5th chapter, this is on page 1625, 1 Peter chapter 5, and verses 2 and 3. Have you got it, Mr. Stewart?
I do.
Yes. Shepherd the flock of God under your care, serving as overseers, not under compulsion, but willingly before God, not for love of dishonest gain, but eagerly, and then this is the point, not lording it over those who are God's inheritance, but becoming examples to the flock. The point being here, another aspect that an elder needs to consider is he does not have the authority to lord it over or take over control of a family arrangement where a person who, let's say it's a victim who is 24, 25 years of age, has a right to decide whether or not they will report that incident. They also respect the family arrangement that the appointed guardian, who is not the perpetrator, has a certain right to. So this is the spiritual dilemma that we have, because at the same time, we want to make sure that children are cared for. So if the government does happen to make mandatory reporting, that will make this dilemma so much easier for us, because we all want the same goal, that children will be cared for properly.
Let's take the situation in a family where one of the children, let's say the eldest, reports having been abused by her father.
Yes, sorry, is there a question?
Yes, if that report is accepted as having validity, you would accept that the potential is that the other children in the family remain at risk.
That is correct.
And by not reporting to the authorities is the case not that the confidentiality of the one who reported is regarded as being more important than to protect those who are still at risk?
No, Mr. Stewart, if I could just, what I'm trying to highlight is there are several factors that make it hard for a minister of religion to make a clear-cut or quick decision on this matter. Obviously, I think, again, what has been highlighted to the Commission, the elders should encourage the guardian of the child or whoever is in that family arrangement that is not the perpetrator to notify the authorities.
Leaving aside the question of overriding mandatory law from the civil authorities, do you see the possibility within the scriptures as you've identified them for a change in the practice of Jehovah's Witnesses? In other words, would it be within the scriptures for the Jehovah's Witness organization to adopt a policy which says that in cases where there are others at risk, a report must be made to the authorities?
That is a possible thing for us to consider, and I think already the assumption is there that if any elder was to see that there was some definite risk, that their conscience should move them to do that. But the point I was trying to make, Mr. Stewart, is there are other scriptural factors that maybe make that a little complicated, and it would certainly be a lot easier if we had mandatory laws on that.
Now, turning to another aspect that we've dealt with, which is the question of the two-witness rule, you'll be aware that if there's no confession, then two witnesses to serious wrongdoing are required, or to two similar events of serious wrongdoing, in order that there is sufficient evidence to establish a judicial committee. Do you understand that?
I do understand that.
Is there a scriptural basis to that?
The two-witness testimony, is that what you're asking, Mr. Stewart?
That's right.
Absolutely. If I could take you to the book of Matthew, chapter 18, Matthew 18, and that's on page 1330. Matthew 18,
Yes,
and here are the
16.
words of our Lord, verse 16, that's correct, the words of our Lord Jesus Christ. But this is talking in the sense of a judicial setting, and if he does not listen, take along with you one or two more, so that on the testimony of two or three witnesses every matter may be established. So from this, and I can give you a list of several other scriptures, but I don't want to test your patience and take you to all these verses. But basically this is a theme right through the Christian Greek scriptures, the New Testament, that the rules for evidence for a judicial hearing involve two witnesses. But please allow me to say further, this is only talking about setting up a judicial committee. It doesn't mean to say that Jehovah's Witnesses would feel that someone is totally 100% squeaky clean just because there was only one witness to the crime.
Well, I'm not sure what you mean by 100% squeaky clean. I mean, the reality is if there's only one witness in the case of child sexual abuse, then it cannot be taken further by the elders, and as it's put in the literature, it's left in the hands of Jehovah.
Yes, but please may I correct your comment on that with all due respect. You see, by squeaky clean, I'm meaning that it's not like someone being exonerated by a judicial hearing whereby there's double jeopardy and they can't be taken before the judicial hearing again. Our literature has said, and we agree, that in most cases with children with child abuse, they are telling the truth. That's an established thing. They're not making up these stories. So immediately the elders would put into place protection measures to help, to make sure that the family cares for the child and that due steps are taken to protect the child.
So I take it you say that that is what elders around the world should definitely do.
They should do, because Christian principles indicate if they realize a child is in a dangerous situation, action should be taken. The judicial hearing is simply us determining whether a person, the perpetrator, has committed a sin that would warrant them being put out of the congregation. But that doesn't mean to say we're stupid and that we think that someone hasn't done something.
Well, I want to take you back then to the scriptural basis for that. So you've referred to Matthew 18, verse 16, and as I understand it, and correct me if I'm wrong, that in turn really is a reference back to Deuteronomy 19, verse 15. In other words, what Jesus Christ was doing is referring back to that aspect of Mosaic law dealing with evidence.
He did quote, as he often did, from the Mosaic law, but he gave a Christian application.
So, but that is an element to be found in the Mosaic law as set out in Deuteronomy 19:15, is that right?
It is an element that is found in both the Old Testament and the New Testament.
Now, what I'm interested in is, and perhaps you can help me on this, is that why that applies to a case of sexual assault when clearly what was being addressed in the reference in Matthew that you gave us was not a question of sexual assault.
Yes, if I can just clarify that a little further then. There are basic principles that the Bible highlights, and I can give you 2 Corinthians 13, verse 1. Sorry, Mr. Stewart?
Yes, carry on.
You can hear me okay?
Yes.
Okay. 1 Timothy chapter 5, verse 19. It's not just a one-off verse, but this is a basic principle for rules of evidence as found in the Bible. But if I could just emphasize again, this is only referring to a church-appointed committee that determines whether a person should remain in the congregation or not. The judicial system, and I'm sure if I can save the court's or the commission's time, I'm sure you're going to want to refer me back to Deuteronomy where it mentions the penalty of stoning. But what we need to remember is the laws that were given back in the nation of Israel. You had the judiciary, you had the punishment system, everything combined together. When the Christian arrangement came about, with our Lord Jesus Christ giving us direction, the Christian church does not have the authority to throw people into prison, to execute, or to do anything to them. So the judicial system in the Christian arrangement involves the spiritual cleanliness of the congregation, and the rules of evidence remain the same all the way through.
Well, Mr. Jackson, that's exactly the point I want to get to. You'll be familiar, and perhaps we can go to Deuteronomy 22, 23 to 27.
Deuteronomy 22, 23 to 27.
Page 304. So where it said that if a man is found lying down with a woman who is the wife of another man, both of them must die together. Now, let me just preface this. I'm not addressing the question of the stoning. I'm addressing the question of evidence. The man who lay down with the woman as well as the woman. Sorry, I read that badly. Both of them must die together. The man who lay down with the woman as well as the woman. So you must remove what is bad out of Israel. Then it says, if a virgin is engaged to a man and another man happens to meet her in the city and lies down with her, you should bring them both out to the gate of that city and stone them to death. The girl, because she did not scream in the city, and the man, because he humiliated the wife of his fellow man. So you must remove what is evil from your midst. And then the next example is the one I'm particularly interested in. If, however, the man happened to meet the engaged girl in the field, and the man overpowered her and lay down with her, and the man who lay down with her is to die by himself, and you must do nothing to the girl. The girl has not committed a sin deserving of death. This case is the same as when a man attacks his fellow man and murders him. for he happened to meet her in the field, and the engaged girl screamed, but there was no one to rescue her. So the point of this last example is that there's no second witness, is there? Because the woman's in the field, she screamed, but there was no one to rescue her. Do you accept that?
Could I explain, Mr. Stewart, that, you see, I think already under testimony, some of Jehovah's Witnesses have explained that the two witnesses needed can be, in some cases, the circumstances. I think, was it an example given?
I'll come to that, Mr. Jackson.
Okay, so
we'll get through this a lot quicker and easier if we just address it one step at a time. So
okay.
the present step...
So the answer to your question?
The present step is this, is that in that example you accept it's a case where there was no other witness beyond the woman herself.
There was no other witness except the woman herself, but added to that were the circumstances.
Yes, well, the circumstances were that she was raped in the field.
Mm-hmm.
And,
yes, but they were circumstances.
And it was sufficient, there being only one witness, it was nevertheless sufficient for the conclusion that the man should be stoned to death.
Mm-hmm. Yes.
Now, is it...
I think we're agreeing on the point.
Yes, is it not the case that had Jesus been asked about a case of sexual abuse, he may have referred back to this part of Deuteronomy and said that it's not required to have two witnesses?
I certainly would like to ask Jesus that, and I can't at the moment. I hope to in the future. But that's a hypothetical question which if we had an answer, then we could support what you said.
Well, it's hypothetical in a sense, but really what I'm driving at is the scriptural basis, and you the scholar, I'm not, is the scriptural basis to the two-witness rule really so solid, or is there not space for your governing body to recognize that in cases of sexual abuse, it need not apply?
Again, if I could just mention the fact that we've already acknowledged that circumstances can also be one of the witnesses.
Well, I'll come to that, but my question is a different one. It's whether the scriptural basis to the two-witness rule in relation to cases of sexual abuse has a proper foundation.
We believe it does because of the number of times that principle is emphasized in the scriptures.
Now, you'll be aware, of course, in the case of adultery, so long as there are two witnesses to the circumstances of opportunity, that will be sufficient.
Yes.
So in other words, there needn't be two witnesses to the act of adultery itself, but only to the circumstances of opportunity.
Sorry, you would need to walk me through that a little further.
Well,
I'm not quite sure.
I was trying to do it by a shortcut, but I'll take you to the document. It's in the same Shepherd, the Flock book, which is tab 120 at page 61. So you'll see you have paragraph 11 there?
Paragraph, yes, I do.
So this is also in the chapter dealing with determining whether a judicial committee should be formed. On the subject of evidence, testified to by at least two witnesses that the accused stayed all night in the same house with a person of the opposite sex or in the same house with a known homosexual under improper circumstances. That's the heading. And then it goes on to say elders should use good judgment in assessing the situation before forming a judicial committee. And in the second dot point, it says if there are no extenuating circumstances, the judicial committee would be formed on the basis of strong circumstantial evidence of porneia,
Mm-hmm.
and you'll see at the foot of the page there's an example of a married brother spending an inordinate amount of time with his female secretary, and 2 lines from the bottom it says, later when he claims to be leaving overnight for a business trip, his suspicious wife and a relative follow him to the secretary's home, and they observe essentially the opportunity of adultery to have taken place, and then those 2 witnesses will be sufficient to establish the case. Do you see that?
I do see that.
So now, in the case of child sexual abuse, it should be, should it not, that a witness to an opportunity for the sexual abuse to have taken place would be the sufficient second witness.
Yes, if there is no, what does it say here?
Extenuating circumstances.
Under improper circumstances.
So a second witness to circumstantial or corroborating evidence would be sufficient to fulfill the second witness requirement.
That's a very large question, and I think it's something that we would need to consider carefully.
Yes, well, it's just important as to whether the second witness has to be a witness to the abuse itself, or to what extent it can be, he or she can be a witness to circumstantial or corroborating evidence. So let me use an example. What about the trauma, evident trauma of the survivor? Would that be able to be taken into account as corroborating evidence?
Yes, it would need to be taken into account. And if I could mention, Mr. Stewart, these are the things that we're interested in following up on after the Royal Commission, just to make sure that everything is in place, because certainly these are the things we're interested in.
Yes, but you'll understand, Mr. Jackson, what we're interested in is how much room you have to move, as it were, to what extent you're bound by the scriptures, and to what extent you have flexibility to change your processes.
That's right. Well, may I mention, I'm sorry.
I was going to say to His Honour, would that be a convenient time for a lunch adjournment?
Mr. Jackson, what did you want to say?
I was just going to say I thought that had already been established in the hearings, but if not, certainly that's something that we need to follow up on.
Very well. Mr. Jackson, it's appropriate that we now take a break for lunch here. We'll come back at 2 o'clock Sydney time.